Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. All right, let's talk about your case management system. Maybe you're still drowning in spreadsheets or stuck with software that feels like it's from 2015. No offense, 2015. The podcast friends at e-Immigration recently published an Ultimate Immigration Software Buyer's Guide. I wish I'd had it when I was shopping for our firm's case management system. It's got real comparisons of the features that actually move the needle. Head to get.eimmigration.com/resources to grab your copy and pick like a pro. Or click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. This week on the podcast, celebrating the release of a very worthy client from immigration prison who had no business being in immigration prison after a habeas fight in federal court. Nationally, Chicago is now under siege, in large part because a large portion of this country is willing to look the other way when the individuals being terrorized speak with an accent, look different from ethnically European Americans, and in some cases do not have legal status in this country. Do not forget, though, that the Trump administration first took away the legal status of many of these individuals, and that the vast majority of them have no criminal record. And did you read about that guy who hit a woman and her young daughter in his apartment for 3 days? What have we become? These are our community members, people who help their neighbors, help the economy, and who contribute far more than they take. They add to this country. And now the military is being sent into Chicago, ostensibly to protect the poor, heavily armed ICE officers being ordered to do these sometimes inhumane things? Hard to explain. To me, there are only two real explanations. One, flat-out xenophobia of those in charge, seeking to cleanse the American gene pool of individuals who, those in power, do not want for reasons based largely in identity and culture. And/or it's two, a very thinly veiled attempt to create a BS need to send the military into places with lots of Democrat voters in order to punish them or intimidate them, or who knows, create a further crisis that eventually leads to a national situation that sure smells a lot like authoritarianism. None of it is good. Or I don't know, maybe three, to distract from Mr. Trump's Epstein problem still smoldering in D.C. 10 months in, 3 years, and maybe a lifetime to go. But hey, I got good circuit decisions for you. Let's do them. And keep up the fight. Our first case is United States v. Rivera-Valdes, published by the en banc 9th Circuit on September 18th, 2025. This is a big en banc decision about illegal reentry prosecutions that I missed a few weeks ago and I have simply not had time to get to since. But time I have found, because of course, en banc decisions are kind of like uber precedent. And I'm sorry in advance if I sound a little sick. My son has been sick himself since he started daycare many months ago. As an en banc decision, quite a few judges dissented in this one because there are quite a few judges on the case. But it's the majority that matters. Here's what they have to say. And by the way, it's important for removal defense because the case is really about case-initiating documents, service, and due process. Mr. Rivera-Valdes is from Mexico and entered the United States without authorization in 1992. He filed an asylum application in 1993, falsely claiming to be from Guatemala and having suffered past persecution. So nothing good about that. That asylum application listed a certain address on a Cleveland Avenue in Portland, Oregon as his residence. Pretty shortly afterwards, quote, the INS mailed Mr. Rivera-Valdes notices approving the application and inviting him to retrieve his work authorization papers. When Mr. Rivera-Valdes arrived to retrieve his work authorization papers, INS officials told him that they knew the Guatemalan identity he presented was false, end quote. Pretty sneaky, INS, but also hard to feel sorry for tricking a trickster. Mr. Rivera-Valdes admitted it right away, though, and he withdrew his application, so I guess they only approved the EAD application. INS personally served him with an order to show cause, or OSC, the pre-1997 case-initiating document for deportation proceedings. It was even read to him in Spanish. Didn't have the date, time, or location of the first hearing, though, and INS said that he'd get a follow-up notice when it was calendared. But that OSC had a typo of INS's own making. It mistakenly left out the word avenue from the address that Mr. Rivera-Valdes had correctly put in his asylum application. So when the immigration court finally sent a notice of hearing by certified mail, it was returned as unclaimed. Similarly with the OSC that INS tried to then mail Mr. Rivera-Valdes for some reason, even though they had previously personally served him. When Mr. Rivera-Valdes didn't show up for the hearing, he was ordered deported in absentia. Over a decade later, in 2006, he was physically removed. He returned unlawfully and when detained in 2019 was criminally prosecuted under 8 U.S.C. Section 1326A. And here we are, appealing that. Mr. Rivera-Valdes moved to dismiss, arguing he hadn't received proper notice of the hearing and that as such the criminal charge couldn't stand, because a valid removal order is kind of a predicate to criminal convictions under these circumstances. The district court disagreed, as did a Ninth Circuit panel. But the en banc court very much agreed. As I mentioned, this is all important in removal proceedings too, because you can collaterally attack a Section 1326 prosecution by showing that the underlying removal proceedings violated due process and were fundamentally unfair. So if these facts here violate due process, seems like they should totally be grounds to reopen an in absentia removal order too, where ordered under similar factual circumstances, right? Right? Lots of Ninth Circuit and old Supreme Court case law exists about what the state must do to notify individuals of legal proceedings, and the Ninth Circuit goes into depth on a lot of it. But at the end of the day, the notice used by the government, quote, must be reasonably calculated to inform parties of proceedings which may directly and adversely affect their legal protected interests, end quote. A Supreme Court decision named Jones seems to be the seminal decision on this, and are you listening, Mr. Burton? But the case law is not in the immigration context, all of that. Often about the property rights of individuals, always of the utmost importance in the old Supreme Court days. Maybe the current ones? The Ninth Circuit applied all of that in a lot of contexts beyond simple property disputes. And at least the Seventh and Fifth Circuits have applied that framework to removal proceedings and DHS actions, respectively. Applies with full force in removal proceedings, explains the Ninth Circuit en banc court. Non-citizens are entitled to due process after all, despite what you may have heard. Quote, and the stakes for an individual subject to removal are no less severe than other legal proceedings, end quote. Many pages on this, but suffice it to say, Jones and all this reasonable notice stuff applies in removal proceedings. Quote, notice by the government must be reasonably calculated to apprise non-citizens of the pendency of removal proceedings and to afford them the opportunity to be present and to participate, end quote. Fair enough. Here's where the rubber meets the road. Quote, where the government learns that its notice efforts have not succeeded, that knowledge triggers an obligation on the government's part to take additional reasonable steps to effect notice if it is practicable to do so, end quote. Failure to do so, it would appear, is a due process violation that makes an in absentia removal order fundamentally unfair. And that, my friends, seems like a big deal. Unmet here, and here's why. First, simply complying with the INA's requirement of mailing an OSC, or I suppose an NTA, doesn't cut it. Due process requires more. Specifically, under Supreme Court precedent, the quote, government is required to consider unique information about an intended recipient, regardless of whether a statutory scheme is reasonably calculated to provide notice in the ordinary case, end quote. Do tell. Next, and after all, Mr. Rivera-Valdes was personally served with the OSC, which warned him about the need to show up for the hearing, update his address, and of the consequences should he appear. Pretty good argument for the opposite side here, not going to lie, and this appears to be the main point of the dissent. It'll also be the main point of ICE in your removal proceedings in opposition to your motion to reopen. But the majority rejects it. Quote, the relevant question is whether personal service of the OSC on Mr. Rivera-Valdes conveyed the required information which would afford him an opportunity to appear at his removal hearing and present his objections. It did not. End quote. The OSC didn't have the date, time, and location of the first hearing, like so many NTAs. So it didn't give him the required notice of the hearing that he missed. Quote, process, which is a mere gesture, is not due process. End quote. Get it, Ninth Circuit? Actually, that's an old Supreme Court quote, so there you go. The Ninth Circuit doesn't actually talk about what obligation, if any, Mr. Rivera-Valdes had to notice that INA had written his address down wrong, so I assume the answer is none. This is, after all, the en banc court remanding a criminal case. Although it actually kind of does get into that. I take it back. Like NTAs, I believe, the quote, OSC did not prompt Mr. Rivera-Valdes to confirm the accuracy of the OSC, end quote. Rather, non-citizens simply must sign it to acknowledge receipt of the form. That is a very different thing. Not affirming anything that is true and correct, much less under penalty of perjury. In this case, quote, it is undisputed that in response to the returned, unclaimed notice of hearing, the government did nothing, end quote. Sound familiar? The district court had to then determine whether there were other practicable options before the immigration court went in absentia. Something I imagine an immigration court in the Ninth Circuit must now do before they go in absentia when the mailing is returned of an NTA or the notice of hearing, what have you. Of course, the rule issued here has an out for the government. Got to follow up when, quote, practicable to do so, end quote. What does that mean? I bet we can think of a lot of arguments about what the government's practical obligations are, my very smart friends. Maybe more importantly, the Ninth Circuit en banc court actually gives some non-exhaustive examples. The government could check its file and see if the address they mailed the notice of hearing to matches it, and if it doesn't, send notice to the other addresses in the A file. FOIAs just became super important, everyone, for in absentia motions to reopen, as if they weren't already. And this aligns with none other than a Fifth Circuit rule, by the way, in Echeverria from 2011. Quote, another alternative for the district court to consider may be whether sending the notice of hearing by first-class mail was a feasible option, end quote. Love it. And again, quote, these suggestions are not exhaustive, and we leave it to the parties to suggest whether other reasonable alternatives were available to the agency, end quote. And to the podcast listeners. Now heads up. I suppose there are arguments that all of this should apply only to OSCs and the pre-arrira scheme and not NTAs, but I personally cannot identify a persuasive argument. Even if the notice thing is one on remand, Mr. Rivera-Valdes has a couple other elements to meet to avoid a conviction here, but those aren't relevant to removal proceedings. Big case. At the end of the day, and Capitalist Chavez from the Supreme Court notwithstanding, I do believe it's time to flood the zone with in absentia motions to reopen in the Ninth Circuit, and the notice of hearing, or of course OSC or NTA, was returned as undeliverable. After all, and to conclude with a bang, quote, when the government learned that its only attempt to notify Mr. Rivera-Valdes of the date, time, and location of his removal hearing had failed, it was not enough for the government to throw up its hands and do nothing. The government was obligated to take additional reasonable steps to effect notice, provided it was practicable to do so, end quote. Wow. Lots and lots of people and entities involved with this one, so I'll just give the congratulations to Assistant Federal Public Defender Stephen R. Sadie out of Portland, who argued the matter. Thank you for your service. And that is United States v. Rivera-Valdes. All right, fine, I'll do the BIA case. Matter of JHMH, published by the BIA. Unreal case, this one. A shutdown decision. That makes this case an essential decision. So important that the BIA had to publish it during a shutdown when government employees are not allowed to be working unless they are working on essential work, as I understand it. Does that make this a super decision? You decide. Mr. JHMH believes he warrants Convention Against Torture Protection. DHS believes he warrants Convention Against Torture Protection. The BIA does not believe he warrants Convention Against Torture Protection. I mean, the issue is literally not in dispute. In any other court of law, that would make the matter moot. But immigration court is not a court. The BIA and the Attorney General really keep trying to remind us in word and deed. I, for one, lament this. Miss JHMH is a transgender woman from Honduras. That is a flat-out pattern or practice asylum grant in the 10th Circuit. Gonzalez-Aguilar v. Garland, Episode 101. Strong case law in the 5th Circuit, too, with Santos Zacaria for transgender individuals from Guatemala. But again, that 10th Circuit one, directly on point, and a pattern or practice decision. Seems like asylum is off the table, though, because of a 1-year deadline issue, that arbitrary statute. The parties stipulated to a grant of cat protection before the IJ during the Biden administration. And let's be honest, that's kind of what's probably really happening here and has been happening for 10 months. A faction of EOIR is trying to attack what they did not like during the Biden administration and give support to IJs who didn't like it either. To say it nicely. This IJ may have been one of those IJs, who knows? But the IJ rejected the stipulation and set the matter for a merits hearing. And for a variety of reasons, Miss JHMH ultimately did not testify. The IJ then denied, relying in part on matter of fefe, quote, finding that the respondent's credibility could not be ascertained without testimony, end quote. That surely can't be a reason to affirm the IJ now, though, right, BIA? As you just vacated matter of fefe on episode 281 and matter of HAAV after a 36-year run of fefe. Both parties moved the IJ to reconsider, but then with the 30-day deadline to appeal approaching, Miss JHMH had to appeal, or she would lose that right, which is really a fun procedural gotcha in immigration court world, because it thereby divests the IJ over jurisdiction of the jointly filed motion to reconsider. So Miss JHMH appealed the denial in chief to the BIA. First, she argued that the IJ should have accepted the stipulation that she testified credibly. But Ms. JHMH apparently hadn't submitted a personal statement or updated asylum application yet, so the BIA agrees that the IJ didn't have to accept that stipulation. One sentence on that. Although, I guess it could be remedied in other cases in the future. Ms. JHMH also argued on appeal that the IJ erred in rejecting the stipulation to grant cat protection and misinterpreted matter of fefe. A winning argument. Implicitly concedes the BIA now that fefe is no more. But never fear, BIA has further guidance to ensure the denial of cat protection. The BIA emphasizes that 8 CFR section 1003.10b requires IJs to exercise their, quote, independent judgment, end quote, in all cases before them, except motions to dismiss filed by OPLA, so ARO can immediately detain asylum seekers and put them in expedited removal and mandatory detention. Okay, that last part may have been me. The first part is definitely the BIA in this decision. And as such, quote, the views of the parties do not supersede an immigration judge's duty to exercise independent judgment, end quote. And as such, quote, while an immigration judge may accept the parties' stipulations in lieu of evidence, he or she is not required to do so, end quote. Restated, the BIA would like IJs to decide issues not in dispute in adversarial proceedings. Stipulations of law, in particular, as to whether a non-citizen has met his burden of proof for relief, cannot be binding on an IJ, explains the BIA. Given that the IJ made quite clear that he would not accept a stipulation here, there was then nothing wrong with holding against Ms. JHMH her decision not to testify, explains the court. On then to the merits of cat protection. The BIA doesn't see the burden met. No mention of that 10th Circuit pattern or practice decision directly on point, though, although in a different circuit, I would think that would be highly relevant to adjudication of a transgender asylum case. Yes, cat and asylum are different, but come on, pattern or practice of asylum against Honduran transgender women already determined by a circuit and no mention of the decision? In this case, seems like some of the evidence submitted might have been outdated, so the BIA relied on that. Also, the IJ quote found that the respondent suffered serious harm by private individuals as a child in Honduras. However, evidence that the respondent was sexually abused in Honduras more than 20 years ago does not establish that the respondent will suffer similar harm upon removal, end quote. Nor is her brother's death in 2007 overly relevant, at least here, with an efficient record as to why the brother was killed. Quote, we recognize that the respondent has submitted substantial country condition evidence of discrimination and ill treatment of LGBT persons, including transgender women, and that some of the harm is committed by public officials. While some of this harm is severe, and the respondent has presented evidence of transgender women being killed, anecdotal evidence of some individuals suffering severe harm is not sufficient to show that a particular non-citizen is more likely than not to suffer harm rising to that level, end quote. So a truly impossible evidentiary standard to meet, no? Unless you first send your client back to the country, make sure he or she gets tortured, and then bring them back with that evidence to present to the BIA. I am genuinely curious to see what type of cat claim the BIA believes is sufficient during these next 4 years. In fact, on that, can I just read from the Third Circuit's Amos decision that we did literally last week on the pod? From Amos, from the third last week, quote, of course, any future prediction is by definition speculative. Denying protection merely because such predictions lack certainty would undermine the relief cat was intended to bestow, end quote. So I don't know. Do with that what you want. Ensuring that Miss JHMH gets removed despite DHS desiring that she obtain cat protection in the United States, the BIA dismissed the appeal. Here's this. Heads up, everyone. There is case law in every circuit, much of it coming from immigration courts specifically, that holds quite clearly that parties are bound by their admissions and concessions in court. That applies to DHS attorneys too, and is an issue slightly distinct from the stipulation issue here. Remember it and do your research. Hit me up for citations if you desire. And I'm sorry, but can I just please read this literal quote from matter of HAAV 1 month ago and relied upon by the BIA in this decision here for another reason. Quote, a formal concession in the pleadings or stipulations by a party or counsel is binding on the party making them and has the effect of withdrawing a fact from contention, end quote. That's what the BIA said a month ago. What a time to be alive. Here's Ira's take on this decision. From his daily email of cases and immigration happenings, be jealous that I'm on it and you're not. Quote, we now have cases allowing IJs to pre-termit asylum and CAT claims to expedite removal because of the backlog, and cases that permit the IJs to take testimony and disregard a stipulation because they don't like the politics of the stipulation, even if it prolongs the case, end quote. That's Ira's take. Would be happy to hear yours. And that is matter of JHMH. Formal greetings to the 7th Circuit, with Vergara Castellar v. Bondi, published by the 7th on October 8th, 2025. This is a short one about a Venezuelan family that was ordered removed in absentia and then tried to appeal that removal order to the BIA. Can't do that, which is why the BIA dismissed the appeal. The 7th Circuit did as well. Now, true, the family was trying to do this pro se without an attorney and probably doesn't speak fluent English. And also true, they did it like 2 weeks later and were really trying to reopen based on an alleged lack of notice of their hearing. So they were trying their best to resolve this on their own, but instead of filing a motion to reopen an immigration court, they filed an appeal with the BIA, which, let's be honest, if you're not an immigration attorney, does sound a bit intuitive. And you know what? That same day that they filed the appeal, they filed the same thing in immigration court, styling it a motion to reopen. So they did do it right procedurally. Belt and suspenders. But an IJ didn't think there was enough evidence that the family had actually updated their address properly with the court and so denied the motion to reopen. Then counsel came in. Counsel didn't appeal the denial of the motion to reopen. The BIA ended up denying the appeal in chief, and that is what this petition for review is about now, the denial of the appeal in chief. But that was not the correct strategy. Even though the family had moved to reopen, this appeal was of the in absentia order itself. Recall. It wasn't appealing the denial of the motion to reopen, even though it's the same arguments. Procedurally, it's important, and the Seventh Circuit affirmed summary dismissal of the appeal of an in absentia removal order that technically the non-citizens had not moved to reopen and then appealed denial of, as would have been the proper procedure. The family is pro se before the Seventh Circuit, by the way, and doing their best to show that they did in fact change their address properly and should have never been ordered to remove that absentia. They may have the facts on their side. They even have new evidence. But the Seventh Circuit can't consider it on petition for review, explains the court. More importantly, to the Seventh Circuit, the BIA, quote, may review an in absentia removal order only if 1, the petitioner moves to reopen before the IJ, 2, the IJ denies that motion, and 3, the petitioner appeals that denial to the BIA, end quote. Because the proper procedure technically wasn't taken to get to petition for review here, this pro se family will likely be removed. And that is Vergara Castellar v. Bondi. And now, a word from our sponsors.
Good morning, Law Office of Aaron Gomez. Trevor speaking. How may I help you?
Hello. I came across your info on Google. Do you by any chance handle 601 waiver cases? My deadline's coming up just like a few weeks away, and I'm having trouble to get it done. Can you help me?
I'm really sorry, ma'am. At the moment, we're at full capacity. We're not taking any new cases on right now.
No way.
That's not just a lost call, that's a lost client. And it happens every day. With Staffy outsourcing, you don't have to say no. Staffy takes care of the heavy lifting, forms, document collection, assembly, and quality checks at a flat rate of $550 per case. No contracts, no hidden fees, and your first 3 cases are free. Say yes to more clients and grow without burning out. Don't just think about keeping up, think about leading. With Staffy, elevating stress and working smarter will let you double down on building your practice. Visit www.staffy.cc or call 786-891-5619 today. That's www.stafi.cc. Or, of course, click on the link in the show notes.
Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Welcome back, you silly, stressed-out gooses. We have Jimenez et al. V. Bondi, published by the 10th Circuit on October 7th, 2025. This case is about nexus and other things. Mr. Jimenez, his wife, and their 2 minor sons are from Bogota, Colombia. They owned and worked in a furniture factory until coming to the United States in December 2022. The parents, at least, have been members of the Colombian Liberal Party since 2012 and supported the party's presidential candidate in 2022. They went door to door and everything. But Mr. Jimenez began receiving threatening calls once a week, as did other leaders and his colleagues. One was even kidnapped and murdered. And I always kind of wonder in these cases how the victims' phone numbers become known to receive these phone call threats, right? Well, here explains the 10th Circuit, Mr. Jimenez, quote, used his personal phone number to publicly advertise his furniture factory, end quote. So there you go. Now, during all of this, Mr. Jimenez was also a law student with a provisional law license and was interning at the National Prosecutor's Office helping victims of domestic abuse, extortion, and other crimes. Busy man. In that capacity, he began representing a woman who was trying to evict a tenant, but it turns out that the tenant was her ex-husband, and it turns out he was a man known as Don Rafa, a leader of a group of narco-trafficking guerrillas politically aligned with the current president of Colombia, Gustavo Petro. Strong words, 10th Circuit. Seems like the property was also being used for very bad things. Later that month, Mr. Jimenez received a threatening brochure at his factory that stated, "Death to snitches" from the Liberal Party. Mr. Jimenez originally ignored it, but then the 2 men showed up and told him to leave the neighborhood at gunpoint. They were blaming him for searches that had occurred on Don Rafa's property. They returned 2 months later, assaulted an employee at the factory, and demanded to know where Mr. Jimenez was. He was out of town. Don Rafa, it seems, was threatening to kill him as a snitch working for the police and who was in politics. A few days later, a very scary thing happened to Mr. Jimenez's son, which was clearly a threat to Mr. Jimenez. They moved to his mother's home in the Bogota countryside and then fled to the United States 3 weeks later. Before leaving, Mr. Jimenez told a police officer what was happening, but the officer said nothing could be done and that police officers were contributing to the problem. That officer told Mr. Jimenez he and his family should leave, and that is what petitioners did, end quote. And yet, the IJ and the BIA deny the family's asylum and related claims, and the 10th Circuit affirmed it. First, the court agreed that all this wasn't past persecution. That phrase in the 10th Circuit requires suffering or harm, quote, in a way regarded as offensive and must entail more than just restrictions or threats to life and liberty, end quote. Emphasis by the court. Even considered cumulatively and unlike other circuits, the 10th Circuit has apparently held that, quote, threats alone are insufficient to constitute persecution, end quote. But I guess they can be? The court concedes that, quote, physical harm is not necessary, end quote, but not met here because the 10th Circuit sees these threats as, quote, mere restrictions or sporadic threats, end quote. This despite lasting emotional and psychological harm to at least Mr. Jimenez's wife, also a petitioner in this case. Quote, rarely, if ever, end quote, sufficient in the 10th Circuit, that is emotional or psychological harm. In the 10th Circuit, at least, according to this panel. Gotta be quite extreme in the Mountain West, it appears, and essentially, states the court. On to nexus then, because past persecution isn't, of course, necessary for asylum, it just helps a lot. Mr. Jimenez and the family asserted that they feared Don Rafa on account of their political opinion. No particular social group briefed, explains the 10th Circuit. And the court doesn't see that as a central reason. Like the agency before it, the 10th Circuit sees the reason as being that Mr. Jimenez was believed to have, quote, threatened Don Rafa's revenue and security, end quote. After all, explains the court, the family brushed aside the earlier, truly political threats before the Don Rafa situation began. Plus, the 10th Circuit believes that the family failed to show that the Colombian government was unable or unwilling to protect them. On this, apparently 2 types of evidence weigh heavily in the 10th Circuit. 1, quote, whether the government stopped or tried to stop the persecutors, and 2, whether the government offered protection to the applicant, such as by placing the applicant in protective custody, end quote. But intertwined in this, explains the court, is whether the government had the opportunity to respond. A failure to report can therefore tank everything, explains the panel, but not always. Fatal here, though. The family exhibited minimal efforts to reach out to the government. And indeed, Mr. Jimenez, quote, and his father both worked or currently work for the government in Colombia, end quote. So the 10th Circuit is having a hard time squaring that one with a failure to report. The two cops that he reported to and told him to leave aren't overly instructive to this inquiry, explains the 10th Circuit. Nor does the court believe it would have been futile, given that it was the Colombian government that was indeed aware of Don Rafa's property and was attempting to search and seize it and stop the illegal criminal activity. A factually weedy decision with one more weed: reasonable relocation. After all, the family went to the Bogota countryside for 3 weeks and didn't have any more problems. Why couldn't they stay? And Mr. Jimenez's family still lives in Colombia, reasoned the court. Quote, and recall that the men who threatened petitioners told them to move out of the neighborhood. They did not threaten the family to move out of the country, end quote. Tough decision. And that is Jimenez et al. V. Bondi. If you're really paying attention this week, you know I'm concluding with this. Villalta Martinez v. Bondi, published by the 2nd Circuit on October 8, 2025. It's a big boy. This case is about cat protection. So many these days seem to be. And it was actually decided in July, but it's now being published. I wonder why. And footnote 1, because the petitioner's attorney requested that it be made precedential. Go for it, counsels with good decisions. Make your motions. Make your non-precedential decisions precedential and make good law. You've already got the win. Mr. Villalta Martinez is from El Salvador and claimed he was violently attacked by MS-13 of that country in 2016, leading him to flee. Attacked with machetes, no less, and a stick. Broke his fingers and an arm. MS-13 continued to threaten him while he was in the United States and to attack his family in El Salvador. Unsure why, but additionally, Mr. Villalta Martinez fears return to that country because he has tattoos, and the Salvadoran government seems to be throwing all young men with tattoos into a gang gulag. Dr. Thomas Boerman served as an expert in this case, a repeat pod expert, but also probably because he is one of the nation's foremost experts in this area. And he, quote, testified regarding the ongoing state of exception in El Salvador, under which the Salvadoran government has arrested roughly 72,000 people since March 2022 in the name of combating gangs, even though tens of thousands of the arrestees have no cognizable linkage to gangs, end quote. And I'm sure those statistics are now outdated and are more. Dr. Boerman testified that not only wouldn't the Salvadoran government protect Mr. Villalta Martinez, but they're his greatest risk. Describing the statistics that the BIA has discounted this year in published decisions, the 2nd Circuit notes testimony that there have been, quote, 174 documented in-custody deaths in the first 18 months of the state of exception, observing those are deaths that are being perpetrated by officials of the state. The state has announced that it will not even investigate those deaths, the majority of which show signs of torture because it has suspended the constitutional protections previously afforded to prisoners, end quote. No criminal record here, by the way. Time-barred asylum claim and no nexus for withholding. That's why we're in cat world. Just noting it. An IJ granted cat protection, discounting some of Dr. Boerman's testimony, although relying on some other parts in other respects. Indeed, the IJ further concluded that his testimony, quote, was in many ways verified and validated by other sources in the record, end quote. And again, cat grant. DHS decided to appeal, although I guess it wouldn't have mattered if they had stipulated, right? And the BIA vacated the IJ's grant. Applying a standard that is now stated in precedential decisions and which is not likely good law or complete in the First Circuit at least, the BIA reasoned that, quote, the evidence indicates that although prison conditions may be difficult in El Salvador, the difficult conditions Mr. Villalta Martinez might experience do not result from the specific intent of a public official to inflict torture on him, end quote. Motion to reconsider denied too. The 2nd Circuit remanded. Seems like the IJ was right. Because despite its efforts to make everything de novo legal review these days, the BIA still has to review IJ fact-finding for clear error. Quote, Clear error review plainly does not entitle a reviewing court or the BIA to reverse the finding of the trier of fact simply because it is convinced that it would have decided the case differently. Examples of clear error include when there might be no evidence to support a finding of fact, or the finding might be controverted by indisputable evidence. A more likely example might arise when an IJ has obviously misunderstood the testimony of a witness and based a finding of fact on that misunderstanding. Situations might also arise where the evidence opposed to the claimant's version, though not indisputable, has overwhelming persuasive force, end quote. But one thing is for sure, explains the Second Circuit. The error has to be clear. BIA messed up here. Quote, on remand, the BIA will have to either accept the IJ's findings or, if it can, provide a supportable basis for rejecting them, end quote. And oh, by the way, here's a legal thing. Quote, barbaric prison conditions might constitute torture if they cause severe pain or suffering and if circumstances indicate that the intent of the authorities in causing the severity of pain and suffering is to illicitly discriminate, punish, coerce, confessions, intimidate, or the like, end quote. Similar to the rule being discussed in the First Circuit. Not this necessary intent to torture, but an intent to cause one of the regulatory listed things that then results in severe pain or suffering akin to torture. A very, very important thing to remember as the BIA issues its slew of anti-cat and anti-Salvadoran and anti-prison condition decisions. So with all that background and I guess a little bit of remand stuff in mind, here are some of the specifics of the case. First, you've got Dr. Boerman's unimpeached testimony. Yes, the IJ discounted that testimony in part because Dr. Boerman couldn't recall all the documents he'd analyzed in this particular case and appears not to have even reviewed the I-589, all things that attorneys and Dr. Boerman would do well to prep to avoid something like this in the future. But the IJ still credited his testimony and qualified him as an expert and, oh, by the way, noted that his testimony was corroborated by the record. Flat out, quote, the BIA's conclusion that Dr. Boerman's testimony was entitled to diminished weight because he did not review Mr. Villalta Martinez or recall if he had reviewed his written statements does not justify finding clear error, absent consideration of other country conditions evidence that corroborated Dr. Boerman's testimony, end quote. Worth remembering. Plus, you've got the tattoo stuff. Mr. Villalta Martinez has them, and Dr. Boerman reviewed the I-213 describing them. So what's the issue? Also, the BIA needs to consider torture in the aggregate, so it's not just prison conditions. It's police and law enforcement singling him out for his tattoos as well, explains the Second Circuit. And here we go. Here is the Second Circuit in a precedential decision, quote, there is record support for Dr. Boerman's testimony that the state of exception has resulted in the suspension of due process rights, including that suspected gang members are killed without trial, end quote. String citing lots of helpful evidence that you can use in your case. Do I have to spell it out for you good people? This is the anti-episode 261 matter of AAR case for Second Circuit practitioners and screw it nationwide. And also, kind of the anti-matter of AAFV case, episode 271. This is the case for your Salvadoran prison condition, state of exception, suspected gang member cases. Do you want specific evidence, BIA, for a cat claim? You always do. Well, quote, the record includes evidence of specific instances of torture and reports of hundreds of individuals being beaten, starved, and medically neglected. Also includes evidence contrary to the BIA's conclusion that such reports of torture are anecdotal, end quote. So I guess this is also a decision to combat the BIA decision that we just talked about this episode. Literally review this decision and just put all the evidence being cited in it and explained by the Second Circuit into your briefs. Pages of parentheticals as well. That includes a section of the decision titled, quote, overcrowding and starvation, end quote. Very important to a cat claim based on prison conditions because, quote, the record also contains evidence that these conditions are intentionally inflicted, end quote. Also, quote, from the start of the state of exception, the government frequently advertised on social media the overcrowded conditions and lack of adequate food in the prisons as appropriate treatment for gang members, end quote. Remember how the BIA rejected similar arguments in AAR? Or maybe it was AAFV? I don't know. Yes, I wasn't convinced by the BIA's position there either, and so here's the Second Circuit saying, actually, that stuff is quite important to government acquiescence. The Second Circuit lists out exemplar tweets from government officials, including President Bukele himself. Flat out, quote, "These public statements, among others, are evidence indicating a specific intent by the government to torture suspected gang members," end quote. The current BIA just hates it. So not even necessarily government acquiescence, I misspoke. This is direct government torture, but also important for government acquiescence, I imagine. Other reasons to grant on remand as well, although I suppose the BIA need not technically. But this is going to be a long decision. And still I must continue. That is my obligation. It doesn't really matter to the court whether it was legal or not to do all these things under Salvadoran law. After all, the Holocaust was legal under German law. That's just me. As the Second Circuit explains, quote, "The regulations do not exempt from the definition of torture those sanctions that defeat the object and purpose of the CAT, even if lawful under local law, such as those that are brutal and highly disproportionate to the penological purpose for which they are imposed," end quote. Think, for example, if live burial was permitted under a country's law. Still torture, right? And that's the Second Circuit's example. In fact, most torture throughout history has been legal, I'd think. Still gets you cat protection in America. Remanding in a giant way, the Second Circuit, well, remanded. And all of it means, congratulations, Aaron J. Eisen from the Erie County Bar Association Volunteer Lawyers Project Incorporated in Batavia, New York, for doing quite the mitzvah for non-citizens everywhere and, of course, your client. No wonder you wanted it to become precedential. And that is Villalta Martinez v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.